Welcome back. Joining us now is Will Worsham. He's going to do our segment on Speaking Legal today. He answers a viewer's legal question on the air. Let's look at the question today. I am currently in a rent-to-own my own contract. My landlord recently threatened to evict me for refusing to sign 21 times on a newly created rules and regulations. What is my legal recourse?
Okay, this is an interesting question. Yeah. Now, a lot of these type of questions are obviously going to be governed by the document that's there. So, you know, the first question that I would have as I'm trying to sort through this for this person is, what's the document look like that they entered into when they took over possession of this property? So they're a tenant, they rent property, they have possession of it, they take that by hopefully a written lease. We've talked about that before. If you're going to be in possession of property, even if you're the landlord, you want that relationship governed by a written document.
Protects both sides.
Protects both sides. So at some point here, there's a written document that determines what the rights and responsibilities of all the parties are. Now, if the landlord is in a position under the terms of that document to terminate that lease, then they can do so under whatever conditions they deem appropriate, barring certain federal other statutes regarding equal housing and things like that. So if they're saying, hey, your lease is up, this is our new document, these are the new rules and regulations. If you want to continue to be a tenant, you have to agree to these rules and regulations before going forward. Then that's something that the tenant is likely going to have to abide by or move out, because they simply don't have right to possession anymore.
But
you want me to answer that, or you want to go? You want me to go?
No, yeah, you go.
Okay.
Those are things I just say, well, that ain't fair, but law doesn't have to be fair. It's just law.
Life ain't
well, that's a good point.
Yeah.
Now, but the situation here is, if we're mid-contract here, if you've got a one-year lease,
that's what I was going to ask.
We're 6 months in, the landlord doesn't have any right to terminate the relationship, then they really don't have any leverage to say, you're going to move out if you don't sign these rules.
Right.
Now, 6 months later, they might be in a position to do that.
They can't change in midstream.
They can't change in midstream, exactly. Now, the one thing about this that makes it just a little bit trickier is this is a rent-to-own. And there's a lot of different ways that can take shape. It's not uncommon that you'll see a straight rent-to-own. You rent, it's going to be applied as payments, and then over time. But a more common scenario is you buy an option. You know, you pay for an option that allows you to then buy the house at a certain price when the conditions of the option are met. Typically, that's going to be when the tenant is then in a financial position to be able to purchase it. Most of the time when people find themselves in a rent-to-own situation, it's because they're not able to afford traditional financing. That's why that becomes an attractive option. Otherwise, it's not a great option if you can go out and obtain a traditional mortgage to buy a house. The downside to that and the renter here is if they don't ever exercise that option, then they've lost that purchase price that they paid for that option. But that's typically the landlord's incentive.
Up front usually, isn't it?
Yeah, you buy that option up front. You can exercise it at any time by the terms of that option. And so there's the risk of the tenant that they're going to lose that. That's typically offset from the landlord's perspective of the risk at putting themselves in that position. That's why they're willing to do that.
Your down payment will not be refunded.
Well, and that's the other trick. A lot of times people think that option price is a down payment. They're two different things. You buy an option, you bought an option. That's all you bought. It wasn't a down payment for the house.
Now, I've noticed in some contracts, and usually they're when you get credit card things in the mail, they put these little things in there. This is why I always read them. It says, we can adjust this rate at any time we choose. Is this something that you really need to read these contracts before you sign?
Every word, probably.
Yeah, you really do need to read those contracts and know exactly what you're getting into. A lot of times they have a universal default clause too. That's what gets a lot of people, which basically says if you default on any loan with anybody, anywhere at any time, we can declare you in default on our loan. So that means even though you're current on your payments to your Visa card, if you're late on your MasterCard, Visa can declare you in default and seek to collect the entire amount that you owe them immediately.
I mean, they can make mistakes.
Everybody makes mistakes.
That's what you signed. Good to have a lawyer look things over.
And it ain't fair, just like you said.
Fair has nothing to do with it. Will, thanks a lot so much.
Thank you, Will.
You bet. All right, if you have a legal question for Will, you can email him at wworsham@color10.com, and he'll answer the question on the show.
All right, Will Worsham, thank you so much for coming in.
You're welcome.
Hurry up. Fat Pike and the bartenders are here to perform. We'll be right back after